one off to the side there. That's open.
You want them to lock?
I think it would be a good idea, at least just until everybody's in.
Test, test.
Okay, it's free seating for the finals, okay? You don't have to sit at your own table. So if your table is back there and you want to come up here to watch the finals close up, you're welcome to do that.
Test, test. Hello.
Should we ask Sherlyn?
Good morning, ladies and gentlemen. My name is Samantha Lowe, and I represent the Claimant, Green Hydro PLC.
Good morning, everyone. My name is Jonathan Teo, and I'll be representing Green Hydrogen PLC.
So you need that.
Call
You need the paper.
Sherlyn.
I want a piece of paper.
थोड़ा ओवर एक्साइटेड हो जाती हूँ पैकिंग को देख के. My hands will hurt.
Let me find it. Let me find out if they have stands. Do you have table stands for the microphones? Because they can't hold them and turn pages. They need two, at least one, but two would be better for each table. Testing, 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 testing. It's directional, so you've got to speak into the mic, yeah? I'm asking, I've asked for stands. So have you noticed it's directional, which means you've got to speak into the mic. I'm going to be sitting right up in front, but I'll be gesticulating wildly if you're inaudible.
English professor. Where? Oh, I can see. He just left out. खुश होंगे भाई कि इन्होंने हमें यहाँ तक पहुँचा दिया कि थैंक गॉड दे लेट अस ब्रेक. इसके कॉल थैंक यू. कोई इंडियन टीम नहीं आएगी मैंने बोला था. क्यों? It's just ego.
Good morning, everyone. My name is Jonathan Teo. Ken?
अच्छा आता मेरे वो मैं सोचूं कि इधर पर अंदर दरगाह पे जानती हूँ मैं. ये तो चिल है भाई. ये तो कुछ भी नहीं है. I think there's one Indian team, but it's a little racist of course. I shouldn't say it. There's API ID also. Candy? Not Candy, but a different one. No, it's not API. It's not. I really don't know which are the. I really have zero clue. लोग बस में हो जाएंगे कॉलेज के बाद. लोग बस में हो जाएंगे कॉलेज के तो जो मतलब ऐसे कहा था ना हमें basically Akshat couldn't do this, Shashwat couldn't do this, Surya couldn't do this, Gauri Dhawan couldn't do this. ठीक है. It doesn't get better than this. It is going to get better. Doesn't get better than this. मतलब like this is the one time we reach finals. We
The
win
best
finals.
performance of our college.
We reach finals, we win finals, and then no one ever has to worry about topping it out. Oh, NLS is here. Oh, GNLU is also here. Where is NLS? नहीं नहीं वो GNLU से मुझे लगा कि NLS है. NLS is not here. मुझे GNLU देख के अच्छा लगा. I like that place. आजा. Helsinki is here. Helsinki. Okay, I guess हमारा झूठ थोड़ा पकड़ा गया. क्या झूठ? मैंने कहा था कि मैं तो पिछले साल गई थी. क्या? हमारे practice hall में arbitrating. Oh my god! You are insane. I am very insane. You should have known that by now. अच्छा हाँ, that is the round I told you that don't tell them, don't open your show your mic. Yeah, ऐसा don't show your cam, don't show your face. याद तो नहीं रहा होगा. Okay, तो बल्ले नहीं हुआ तो शावा. But मेरा तो भाई रिवेंज होना चाहिए. होगा. It'll happen. कुछ भी ना करते सीधे मतलब सड़क से उठा के एक टेबल पे लाइक स्टार ही बना दिया भाई आज तो हाँ। मैं तो पैकिंग को सीधे गले लगाने वाली हूँ ठीक है मुझे तो बिल्कुल बहुत पसंद है वो मूवी अरे वो आ रहे हो गई इनसे 10 बज गए ना भाई मैं टर्की कॉन्ट्रैक्ट का केस नहीं याद आ रहा है Remember to smile of always. भाई नेपाली नहीं तो भाई मेरा नेपाली आउटफिट आ गया अरे वाह ओह भाई मुझे तो कितने क्यूट लग रहे हैं यार ये लोग तो आई फील वेरी हैप्पी कि वो लोग इतना आगे आ गए मतलब they must have improved a lot यार and that just shows their effort that they have put in the work yeah मैं सोच रहा सेकंड को अपनी टेबल पे बुला लेता टेबल
Claimant. No, respondent.
Respondent, yes.
Okay. Names.
Ashika.
Who's the first speaker?
Ashika.
You're the, okay.
ASH
A,
S
S,
H H
2 S's?
no
Ah, Ashika.
yes
Yadav.
yes
This is respondent.
respondent proceed
And first speaker. And the second is Nishta or Nishta?
Nishtha
Nishta. Last name? So you get in. Say again.
Barua
Barua or Barua?
Barua
Barua. Okay. This way. Claimant.
Aria Equatoriana Ren Power Limited.
Sorry, so you guys will get the 10. 1 stand each, you guys share.
It's limited, right?
这个不是第三个。
Oh, okay, that's all I need. That's all I don't need that. Thank you very much. It was a simple task.
You don't need a podium.
Keep your water towards that side. It will be easy for you to reach it also.
That's all.
Wait.
Okay, so then the team, each table gets one.
Okay.
Yes, I want to test, but I want to see. Good morning, ladies and gentlemen. My name is Samantha Lowe, and I represent the Claimant, Green Hydro PLC. Want to try?
Yeah.
Put it down.
Why is it so imbalanced?
Weird.
Good morning, Mr. Presiding Arbitrator, members of the tribunal.
Good morning, everyone. My name is Jonathan Teo, and I will be representing Green Hydro PLC. Sorry, we're just doing mic checks.
Yes, this mic does work.
Sorry, can you, I'm just wondering whether you can get this slightly away from you. Can you?
Yes, I think that would
Because
be
it's, and then you can move it over to try again.
Can you also bring closer to you?
It's going to bother you if it's right in your face.
Yes. Good morning, everyone. Oh, good morning, everyone. My name.
Okay, you're going to have to with that in your face like that. You have to be.
Okay, let me
And
just.
watch out because I think you're not going to be audible unless you really project as if you were talking to that whole room. Yeah? Okay.
I can't keep my hands also. देख के सब हंस रहे हैं भाई. Good morning, everyone. Yes.
This one. Reading is quite tall. So when she got up, right, then after that they were like, okay, respondent for cerebral. She had to go up, like squeeze the mic down. Everybody freaking laughing.
Good morning, everyone.
No,
Good morning, everyone.
and then presiding.
Good morning, everyone. Works?
No, the presiding judge was basically saying at the ICJ the podium moves. You don't have to move it.
Good morning, everyone.
They were like, and then everyone like was so
Good morning, everyone.
How do you shut it? Good morning. Good morning, everyone. Good morning, everyone.
For those of you who are sitting at the back, if you're sitting there because it's your table and you'd like to come up closer, feel free to do so during the final arguments. And again, I repeat the warning, please do not put anything on the tables, don't touch anything on the tables, and don't leave anything when you're leaving the room. All bags, phones, everything have to go out of the room when we leave it, to leave the place pristine for when we come back. All right? So can we proceed? Are we ready?
Good morning, everyone. Good morning, everyone.
Can we proceed?
Is there a way to switch this off? Is there a way to switch this off and only turn it on when we are speaking?
You should turn it off when you're not speaking.
How to turn it off?
It's down here, I think.
Can I?
No, just turn it away from you so that it's, you turn it to her and then when they're speaking, just turn it away. It should be okay.
Should I ask them if
Okay.
it's audible or not?
Good morning, everyone, and I'm sorry for the delay, but we have a new venue, and it's very exciting to be in this wonderful hotel, but a few technical glitches, so we are now ready to proceed. So, welcome to the 22nd edition of the Vis East International Commercial Arbitration Moot. This morning's argument is between Green Power PLC, the claimant, represented by Samantha Lowe and Jonathan Teo. The respondent, Equatoriana Ren Power Limited, is represented by Ashika Yadav and Nishta Braua. Our arbitrators, if they would please come to the stage. We have Pilar Pereles Vizcayas from Madrid, Spain. We have Hendrik Sanoji, I hope I pronounced that fairly well, from Helsinki, Finland. And in the chair, Catherine Mun of Hong Kong, Singapore. And we welcome them, and please proceed.
Good morning. Welcome to the arbitration proceedings, Moot 100 of 2024, between Green Hydro PLC, the claimant, and Equatorian Ren Power Limited, the respondent. Before we get going, may I introduce myself? I'm Catherine Munn, the presiding arbitrator of these arbitration proceedings.
So, good morning to everybody, and good luck to both the teams. I'm Pilar Perales Vizcayas, commercial law professor at University Carlos III of Madrid.
Good morning, everyone. My name is Hendrik Sanoji, and I'm the Secretary General of the Finland Arbitration Institute. Good luck to both teams.
Thank you. These proceedings will deal with 4 preliminary issues, and they are set out in Section 3.1 of the Procedural Order Number 1. And so may I now introduce the parties, the participants to introduce the people that are coming for this hearing today. Shall we start with the claimant?
Madam President, members of the tribunal, good morning. My name is Samantha Lowe, and together with my co-counsel, Mr. Jonathan Teo, we represent the claimant, Green Hydro PLC.
Thank you.
Madam Presiding Arbitrator, members of the tribunal, my name is Ashka Yadav, and I, alongside my co-counsel, Ms. Barua, represent the respondents, Equatorial Rent Power Limited.
Thank you. To accord with the principle of equal treatment, each party will be allotted the same time duration, which is 30 minutes. And during the course of your oral presentation, the tribunal may have questions to you. Our questioning time will be counted, will not be counted towards the 30 minutes time slot. And I would just want to inquire, have the party discussed about the order of presentation as well as the time assigned for dealing with each issue?
Yes, parties have agreed on the order of speaking. Because respondent is bringing a jurisdictional challenge, respondent will begin first for the issues on procedure, followed by myself. For the issues on the governing law of the contract, my co-counsel, Mr. Jonathan Teo, will begin first, followed by respondent's second counsel.
And for the rest of the issues that will be dealt with by the claimant first?
So for the issues on procedure, respondent will begin. For issues 3 and 4, which are on the governing law of the contract, claimant will begin.
Thank you. So may we start with the respondent?
Yes. Madam Presiding Arbitrator, members of the tribunal, and distinguished colleagues, a very good morning. My name is Ashka Yadav, and I, alongside my co-counsel, Ms. Nishtha Barua, represent the respondents, Equatorial Rent Power Limited, in the present proceedings. Members of the tribunal, a contract is like a map. It guides both parties, setting clear boundaries and directions. Yet the claimant now seeks to redraw these lines, ignoring the path we both agreed upon. Thus, I'll be addressing the tribunal on the two key procedural issues. Firstly, the tribunal should reject the claim, and secondly, the tribunal should include Respondent Exhibit R3 and should exclude Claimant Exhibit C7 from the record. Beginning with my submissions, members of the tribunal, the claim should be rejected as the requirement of mediation is a condition precedent and the mediation in the present case is not futile. And if I may direct the attention of members of the tribunal to page 12 of the record. Page 12 contains the purchase service agreement. At the bottom half of the page lies Article 30 of the PSA, within which is a multi-tier clause, and the wording of the clause is that the parties shall first mediate and finally arbitrate. Members of the tribunal, the wording of the clause in itself is sufficient. It uses the mandatory language of the word shall and provides a sequential order for the proceedings that the parties must first mediate and then arbitrate. However, in the present case, the claimant have not fulfilled the requirement of mediation. In the case of International Research Club versus Lufthansa, wherein there was a similar clause using the word shall first, and lastly, it was held that the requirement of mediation would be a condition precedent and the claim should be rejected. Furthermore, members of the tribunal, in the present case, the claimant themselves deviated from the FAI model mediation clause. And if I may direct you to page 31 of the record. Page 31 contains a communication made from the claimant to the respondent, and therein, at the last paragraph, and if I may read it for the tribunal, at the last third line. Furthermore, the FAI model mediation clause suggested by us clearly provides that the parties must first try to mediate their dispute before resorting to arbitration. Thus, arbitration is only the last resort as you wished. Members of the tribunal, the claimant themselves has conveyed to the respondent that the arbitration in the present case would be a last resort, and they have deviated from the FAI model mediation clause. This deviation showcases exercise of party intent and autonomy to make mediation a condition precedent. Thus, the claim should be rejected. Furthermore, if I may preempt the argument of my opposing counsel, it is most likely to be that the clause does not contain a time limit, rendering it unenforceable. However, the parties have sufficiently agreed to the FAI framework and the FAI mediation rules, within which Article 2.2e provides that when requesting for mediation, the parties can submit a time, and as seen in the case of Cable Wires versus IBM, when the parties have agreed to a framework of mediation, even if there is no time limit mentioned specifically within the clause, the clause in itself becomes enforceable. This leads me to my second submission on this first issue, that is, the mediation in the present case is not futile. Members of the tribunal, mediation is not immediate enforcement of cooperation, but rather a collaborative process wherein certain elements emerge. While the parties may seem at an impasse at the start, a skilled mediator can resolve any dispute. In the present case, the respondent sought a price reduction of 15% when the claimant failed to fulfill its obligation and submit the plans on time. And this was the only reason the respondent sought the price reduction, because it was under intense public scrutiny, and to ensure that the claimant would further its obligation on this project. The main reason that the claimant was performing this project was to use it as a reference project, and they had previously agreed to a 5% price reduction because their PEM electrolysis technique was not considered to be reliable. Thus, a further price reduction to the claimant would not have been unavoidable, and the parties could have successfully mediated, and thus the mediation should have been the first step instead of the arbitration, as the same was provided in the agreement of the parties.
Thank you, Councillor. May I ask you a question? How the arbitral tribunal should interpret your silence, I mean the client's silence, in regard to Exhibit C7?
Madam Arbitrator, that is precisely our next submission, and we submit that Exhibit C7 was a genuine offer, and while the wording in the clause in itself might seem not like a genuine offer, it was a standard commercial negotiation tactic. If I may direct members of the tribunal to Exhibit C7 and address the admissibility of it. Exhibit C7 lies at page 20 of the record. Exhibit C7 is a without prejudice offer made by the respondent to the claimant, and therein at the last paragraph, while what it may seem like an offer that is harsh, if I may read and interpret it for the tribunal. To be competitive, we need a price reduction of 15%, if not more. And at the last line within which, if Green Hydro is willing to accept a serious price reduction of 15%, or at least a two-digit number. Members of the tribunal, the respondent has first asked for a price reduction of 15%, if not more. However, in the very next line, they have said that they are also willing to accept a two-digit number, which showcases which can also be 10. This was a standard commercial negotiation tactic, and our CEO, Mr. Lacour, was known to be a tough negotiator. This showcases the fact that the respondent had a genuine intent to negotiate. Furthermore, this offer was made after the respondent had validly terminated this contract. When the respondent had terminated this contract, but the claimant showed its interest in further completing this contract, as seen in the first paragraph, following our last meeting, I had a discussion with the minister. The respondent in itself engaged with the Ministry of Equatoriania to further this project, and a valid concession has been made, as the claimant could have used this offer to showcase that the respondent termination was not valid, even though it was, and the respondent only provided this offer to showcase the fact that I sense a concern, Mr.
Thank you, Councillor. Do I understand correctly that you're saying that your client would have been open to mediation or continuing the negotiations after sending the exhibit that we're now, or the email that we're now discussing.
Yes, Mr. Arbitrator.
Right. So once the negotiations then broke off, why didn't your client then suggest to mediate or to try to find an amicable solution instead of silence, which then left to the claimant to initiate these proceedings?
Mr. Arbitrator, while the respondent was silenced, respondent was also renegotiating several other contracts as seen in the procedural order 2. Furthermore, the respondent did not expect the claimant to start the proceedings, as the burden lies on the claimant to start the mediation as they are initiating the arbitration. For the respondent, there was a valid termination of the contract and there was no dispute per se.
Counsel, 2 questions. Firstly, you suggest the claimant should start the mediation, but now you are in dispute as to the interpretation of the mediation clause and arbitration clause. This is also a dispute that can be referred to mediation. That's my question 1. And so I have a question, why not the respondent also start the process if he considers it to be important? And then other question is, would the respondent be open to staying the proceedings for doing the mediation?
Madam Presiding Arbitrator, the burden lies on the party initiating the arbitration to initiate the pre-arbitral step, which is mediation. Furthermore, the respondent would not be open to a stay of proceedings, as the very objective of mediation is that parties come to it within an open mind. And if the opportunity of arbitration lies, the parties would not come to mediation table with an open mind and with an intent to negotiate successfully.
So are you prepared to agree to suspend the proceedings or to stay the proceeding to do mediation?
Madam Arbitrator, we would first like the tribunal to reject the claim. However, if the tribunal does not reject the claim, we'd be open to a stay of proceedings so that the parties can refer back to the mediation. Furthermore, if a pre-arbitral step is not met, in Equatoriania, there is consistent jurisprudence that the requirement of mediation is condition precedent. And if an award is rendered and the contract is performed to be in Equatoriania, then the same would be jeopardized. This leads me to my submission regarding the admissibility of Exhibit R3, and the same lies at page 32 of the record. And if I may direct the tribunal to page 32. Members of tribunal, Exhibit R3 is an email from Head of Legal Department, Ms. Heidi Smith, to the claimant CEO and claimant's chief negotiator. Members of the tribunal, while this document may seem like it is governed by legal advice privilege, however, this is a document in which Ms. Heidi Smith is an in-house counsel, and as seen in the case of Agbo versus Nobel, wherein advice was given on a draft of an email, as in-house counsels lack sufficient independence from the employee that they work under, they are not governed by legal advice privilege. Furthermore, the law that might be applicable to this document in itself would be the law of Mediterranean, as the communication takes place in Mediterranean and Ms. Heidi Smith is admitted to the bar in Mediterranean. The legitimate expectation of the party would be to only apply the law of Mediterranean, as this communication in itself took place before the conclusion of the contract. And if I may direct the tribunal to the next page of the record. Therein, at the last paragraph, and if I may read it for the tribunal. So far, Danubia has no rules on legal privileges protecting such documents from disclosure. And therein, at the same paragraph, at the eighth line from the bottom, it seems that only Mediterranean, the situation is comparable to that in Danubia. Members of tribunal, within the applicable law of the document in itself also, there is no legal advice privilege. Thus, this document should be admissible.
I have one question to you, Councillor. Assuming that piece of paper is indeed legal advice or contains legal advice, was that legal advice then followed? And if it was or wasn't followed, does that carry any relevance to the test of whether privilege applies or not?
Mr. Arbitrator, the case record is silent on the fact that whether this legal advice is followed or not. However, the relevance of this document to the respondent is that the claimant had claimed that its negotiations with P2G were going to be successful and the local consent requirement would be met. However, in the email, they have admitted that their negotiations with P2G were going to fail. And this showcases that while performing this contract, the claimant was not operating in good faith and was not transparent to the respondent regarding the local content requirement it considered essential for the contract. Furthermore, Exhibit R3 is not illegally obtained evidence, and the standard of it is of clear and convincing evidence. And the claimant themselves have admitted that there are two possible ways of obtaining this document, and they are merely speculating. Thus, Exhibit R3 is not governed by legal advice privilege and is not illegally obtained and is hence inadmissible. This marks the conclusion of my submissions, and now I'll pass on the floor to the claimants.
Sorry, Councillor, I have a question. If the arbitral tribunal were to decide to exclude both documents from the file, but then the arbitral tribunal would need to be withdrawn from this case, considering that we could be considered to be biased because we know already the content of those documents?
Madam Arbitrator, we trust the tribunal to not be biased, as arbitrators are themselves considered neutral parties. Furthermore, if the tribunal excludes both of the documents, it would cause prejudice to the respondent, as Exhibit R3 is highly relevant. As the claimant has sought a specific performance of this contract, while the claimant themselves, while previously performing this contract, were not operating this in good faith. This is important to establish the validity of a termination.
Madam President, members of this tribunal, good morning. Parties contracted to construct a green hydrogen plant in Equatoriana, respondent's state. Upon a change in the economic circumstance, a change in government, and a corresponding change in government strategy, respondent unilaterally terminated the contract in breach of Article 28 of the Purchase and Service Agreement. It further seeks to delay the efficient resolution of the dispute by challenging this tribunal's jurisdiction, as well as admissibility of evidence that is not protected by privilege. Given this backdrop, claimant makes two submissions. One, that this tribunal has the jurisdiction to hear the present claim and should admit the claim to be heard now, because mediation between the parties would not be purposeful. Our second submission is on the admissibility of evidence. We say that Claimant Exhibit C7 should be admitted because settlement privilege does not apply, and Respondent Exhibit R3 should be excluded because it is protected by legal advice privilege. Turning to our first submission on the jurisdiction of this tribunal. Earlier, counsel for respondent argued on the basis of the wording in the clause set out at page 12 to 13 of the record, which is Article 30. This is the multi-tiered dispute resolution clause agreed to by parties, that a condition precedent can be found in the pre-arbitration step of mediation. However, all they can evince from the wording of this clause, as well as the relevant circumstances, is that parties agreed to a sequence of proceedings. What cannot be found is that parties intended that the consequence of non-compliance to the pre-arbitral step would lead to the deprivation of this tribunal's jurisdiction. And this is very well supported in current jurisprudence, such as in the 2024 Singapore International Commercial Court case of CZQ and CZS, as well as the 2023 Hong Kong Court of Final Appeal case of C&D, which determines that pre-arbitral steps are merely procedural issues that a tribunal is best placed to determine. As such, a consequence cannot be found on the clause or in pre-contractual negotiations, this tribunal has the jurisdiction to determine this claim. It should exercise its jurisdiction to admit the claim, and mediation between the parties would not be necessarily enforced because mediation between the parties would be not purposeful. And this is because of respondents' coercive tactics in negotiation that led to a point of futility. The futility exception in the case ICC 26290 states that the standard for futility is one where parties have reached a point where there is no reasonable prospect of amicable settlement, then mediation should not be enforced. And in that case, where one party strong-armed another party using coercive tactics such as threats and arrests, then the point of futility had been reached. And similar facts can be seen in our case at page 36 of the record, and this is Claimant Exhibit C8. This is the witness statement of Mr. August William Damon, who was Claimant's head of contracting. This is page 36 of the record. At paragraph 3, it states, and I read, on the 28th of April, before negotiations had failed, I had a discussion with Mr. Lacour in which he raised serious allegations against me. On the next line, it states, he informed me that should there be no amicable settlement tying such a threat to the present dispute and the amicable settlement, he would hand over that information to the prosecution's office for an investigation. And this threat manifested 2 weeks later, as can be seen in paragraph 5, which states, 2 weeks later, the police raided my office, confiscated all my documents, and detained me for 2 days in prison. His passport was withdrawn, and he was requested to report daily to the police. And therefore, under these circumstances, there is the point that there can be no reasonable prospect of amicable settlement was reached.
But would that be too prejudgmental? Because usually when people start negotiation or mediation, they would go with the high ball to ask for very much. And then you only know when you go into the process that whether that may produce outcome. So in that case, assuming there is a breach of that mediation clause, would it be right that we should step down? If not, what should be the legal consequence, you say?
In terms of a legal consequence for the breach of the mediation clause, if the tribunal determines that it will admit the claim to be heard now, this tribunal can consider costs or damages rather than instead of staying proceedings for mediation or refusing to hear the claim in totality. We do understand that parties who meet at mediation are necessarily at an impasse, and they will be using high-ball offers. However, it is not the commerciality of the offer that we contend in this case. Instead, it is about respondents' coercive tactics and respondents' strong arming of claimant that will not lead to any reasonable prospect of settlement.
And also for the claimant, are you open to us staying the proceedings to mediation?
Our position is that because there is no reasonable prospect of settlement, there is no purpose to stay proceedings for mediation at this point, as it would only lead to a delay in the efficient resolution of this dispute. Turning to my second submission on the admissibility of evidence, we suggest that this tribunal approach it in a principled framework. Under Article 34 of the FAI rules, this tribunal has the jurisdiction to determine the admissibility of evidence into present proceedings. As parties have not agreed on the relevant rules of evidence, we submit that this tribunal should be guided by the IBA rules on the taking of evidence, particularly Articles 9.2 and 9.4, which set out that this tribunal shall exclude any evidence that is protected by privilege. And in determining the governing law of privilege, this tribunal should consider the principles of fairness,
equality as well as legitimate expectations. Turning first to the first piece of contentious evidence before the parties, and this is Claimant Exhibit C7, which can be found in the record at page 20. Earlier, Madam Arbitrator had asked counsel for Respondent whether or not the offer was genuine, and the question related to their point on futility of mediation. And they used Claimant Exhibit C7 to support their argument that mediation would not be futile. This should constitute a waiver of their challenge to the admissibility of this piece of evidence. Even if we don't consider this piece of evidence, we don't consider that Respondent has waived its right to contest this piece of evidence, we say that settlement privilege does not protect such a document because, one, Respondent bears the burden to prove that settlement privilege exists, and two, there is no genuine offer to settle the dispute on the face of this letter. And I will tackle the last bit. In the last paragraph on page 20, which counsel for Respondent took this tribunal through, she said that a 15% or 10% offer would settle the dispute. However, it reads, and I quote, "Any further discussion between us or our lawyers only makes sense if Green Hydro is willing to accept a serious price reduction of 15% or at least a two-digit number. Therefore, this 15% was never capable of settling the dispute. Instead, the 15% offer was merely to buy Respondent's participation at the negotiating table and therefore cannot qualify for settlement privilege and therefore should be admitted to the record." Turning to our second piece of contentious evidence before this tribunal, which is Respondent Exhibit R3, which can be found on page 32 of the record. First, this is an internal memo that has found itself in the hands of the Respondent. This is an email sent by Claimant's head of legal to Claimant's executives, and in the first paragraph, as any good lawyer, she sets out the subject of the email, and she states that it is a closer look at the law of Equatoriana concerning assurances and misrepresentations, thereby qualifying as legal advice. Our contention here is that, one, it is improperly obtained. We do not argue it as a separate ground that this tribunal should dismiss this piece of evidence. Instead, we say this tribunal should consider this fact when determining whether or not this tribunal should allow Respondent to take advantage of improperly obtained evidence. Our main contention is that it is protected by legal advice privilege.
Just a question here. Does this actually, I have a question whether this is really a proper legal advice or constitutes legal advice, considering that, as far as I understand, Ms. Smith is admitted in the Bar of Mediterranean, and she is giving advice on the law of Equatoriana, and furthermore, she's a labor law, I think, not a contract law lawyer. So could you please refer to this?
Thank you, Madam Arbitrator. We say that it is protected by legal advice privilege under the highest protection test, which extends the broadest protection expected between the parties to protect this document. And in Equatoriana, it is legal advice privilege is provided for when legal advice is given by in-house counsel, and this can be confirmed in procedural order number 2 at page 55 at clarification number 29. We say that the closest connection test as submitted by the Respondent cannot apply because the effect of this would be the unsatisfactory factor that two laws will govern privilege between the parties. Respondent will be protected by legal advice privilege as they hail from Equatoriana, and claimant will not be protected by legal advice privilege because claimant is from Mediterranean. And therefore, to cohere with principles of fairness and equality between the parties, this tribunal should apply the highest protection test, and Equatorian law applies to legal advice privilege, protecting this document, and therefore should exclude this document from evidence.
But let's say if we don't apply this test, we just look at what the law of Mediterranean would say about attorney and client privilege. If that's the case, how should we approach the issues? Anything you rely on to say that the document is still protected by privilege?
Madam President, we say that this tribunal should be guided by legitimate expectations. As parties decided on dispute resolution under international commercial arbitration rather than court proceedings, it never legitimately expected that domestic rules of evidence apply, and therefore one rule should guide this tribunal to determine legal advice privilege between the parties, unless I may be of further assistance. I conclude my submissions.
Members of the Tribunal, the claimant has primarily relied on the futility exception to admit the claim. However, the futility exception originates in investor-state arbitration, and the standard of futility is several negotiations over years, as seen in the case of Tenbe versus Argentina. Herein, only 2 short meetings have taken place between the parties. Thus, the threshold of futility is not met. Thus, the parties should mediate. This marks my conclusion of my rebuttal.
Madam President, members of this tribunal, 2 points. The futility exception has been accepted in international commercial arbitration, as cited in the case number 26290. Additionally, the futility exception is determined on a multifactorial approach, not just by duration alone. Where parties are at an impasse and cannot come to a settlement, the futility exception would be met.
Just for you, a similar question that I also made to counsel for Respondent. If the arbitral tribunal decides construction contract to key contract more than a sale of goods, and then if I may keep on, I would like also to know about Article 4 of the contract, where you see here the customer's obligations, and I would like to know whether those would be relevant for the analysis, not for 3.2, but for 3.1. Of the convention, whether actually it is the customer here is providing a substantial part of the materials necessary for the manufacture or production. Thank you.
Madam Arbitrator, to first answer your question on the preamble of the contract, claimant acknowledges that in turnkey contract, perhaps tribunals might be inclined to take the position that it is a preponderant provision of services. However, it must be noted that past tribunals, such as the 2019 industrial plant case in the ad hoc arbitration tribunal, have determined that the CISG applies to construction contracts, and the decisive criteria is what parties' intentions were. Now, turning to Article 4 and whether it is relevant.
Just one question, because in that case that you are referring to, it was really a turnkey or it was a semi-turnkey contract?
In that case, the seller's obligations was to design, manufacture, supply, inspect, test, transport, to provide training services, installation, and commissioning of the plant. And this is similar to our contract in question, a turnkey contract. Nonetheless, the tribunal still applied the CISG because of parties' intentions. Now, Article 4 may be relevant to Article 3, Paragraph 1 of the CISG. However, Respondent has not put forth this contention, and therefore, claimant will be focusing its attention on Article 3, Paragraph 2. Now, claimant submits that parties' intentions would lead to the conclusion that it is a preponderance of delivery of goods because claimant was the only entity who could perform this contract within Respondent's short timeline, and this is because Claimant had two key component goods, namely the transformer and the electrolyzer stacks. If the members of the tribunal would turn with me to page 16 of the record. Page 16 of the record is Claimant's CEO's witness statement, and at paragraph 8, line number 2, at the middle of the line it reads, and I quote, "At the time of contracting, there was a considerable lead time of close to 3 years for the necessary transformers. That made the realization of the project within 2.5 years largely impossible for all companies, which neither had a suitable transformer in their portfolio nor had at least ordered one before the tender process started." And this is corroborated by a newspaper article found on page 14 of the record. At page 14 of the record, at the left column, last paragraph, it states, and I quote, "While for most other bidders, the long lead times for transformers made the deadline unrealistic, Green Hydrogen, Claimant's company, had apparently guaranteed during the negotiations to have a transformer of the correct size available from the beginning of 2024. Now, already on the transformer good, the tribunal can see that Claimant was the only entity who could perform this contract due to the scarcity of transformers. Now, Claimant further contends that Respondent engaged Claimant because of its patent production process, which was embedded into its electrolyzer stacks. And this can be seen at the contract itself on page 10 of the record. Page 10 of the record is the contract in question. And at paragraph 4 of the preamble, the tribunal will see that parties have applied their minds to it and opined that whereas Green Hydro PLC, Claimant's company, is a leading producer of electrolyzers with experience in the use of PEM electrolyzers and the owner of a protected production process. And on this basis, Claimant submits that the only reason Respondent contracted with Claimant was because Claimant had two key essential goods, the transformers and the electrolyzer stacks, and therefore the preponderant part of today's contract is a delivery of goods contract. Now, if the tribunal is with me, I turn to my last submission. Claimant submits that parties have not excluded the application of the CISG. The power to exclude the CISG is derived from Article 6 of the CISG, which reads, and I quote, "The parties may exclude the application of this convention or, subject to Article 12, derogate from or vary the effect of any of its provisions." Article 12 is not relevant because it deals with state-level derogations. What this tribunal is concerned with is whether parties intended to exclude the convention. And in determining this intent, there must have been clear, positive, and unequivocal intention between the parties for the exclusion, and this finds support in the CISG Advisory Council Opinion number 16, as well as Professor Lisa Spagnolo's article on CISG exclusion and legal efficiency. The starting point for determining this is the governing law clause of the contract, which can be found at page 12 of the record. Page 12 of the record is the contract, and it reads, "The agreement is governed by the law of Equatoriana to the exclusion of its conflict of laws principles." The second half of the clause is not relevant because that aims to avoid the doctrine of renvoi, which means that parties did not want other jurisdictional laws to apply. Therefore, the focus should be on the first half of the clause, and where parties have agreed to the law of a contracting state, then the CISG applies. Now, I note that Respondent might point to certain facts to show that Claimant intended to exclude the application of the convention, namely the change in the model contract as was argued at paragraph 128A of Respondent's written submissions. However, Claimant opines that this cannot amount to exclusion because the issue of applicable law was never discussed at the negotiating table. Now, I note that my time is about to elapse. If I may have 1 minute to wrap up this submission.
Yes.
Thank you. If members of the tribunal would turn with me to page 53 of the record. Page 53, this is procedural order number 2. And at paragraph 11, the background for this question is that Mr. Law was the head of legal to discuss the issue of applicable law. And at line 4, starting with the words transaction with another government entity, the tribunal will see it reads, originally, a meeting between Mr. Law and Mr. Cavendish had been planned for the day before the first meeting with Ms. Faraday, in which the different items on the list referring to the issue of applicable law were to be discussed. However, a few lines down, it states, on the day before the meeting, it was discovered that Mr. Law had leaked important information to one of Claimant's competitors, which led to the immediate termination of his contract. And therefore, parties have never even discussed the issue of applicable law. So how can the respondent argue that there was ever clear, positive, and unequivocal intention between parties to exclude the convention? And on this basis, Claimant submits that the CISG is applicable to this contract. And that concludes my submissions.
Yes, I have a question. You mentioned that we should exclude the two options in terms of arriving at the value under the economic value test. If we are going to include the options because they are part of the contract at the time of the conclusion of the contract, what would be the value?
Even if the tribunal includes the value of the options, the preponderance would still be a delivery of goods because, as clarified in Annex 1 of the arbitrator's brief, the extended table provides for the value of the options where it shows the preponderance of those options are in the delivery of goods, and therefore it would not change the analysis of whether the preponderant part of the obligations are a delivery of goods or provision of services based on the economic value test.
But in terms of percentage, do you know, you mentioned without the options, the percentage would be 63%. But with the options included, what will be the percentage?
With the options included, the percentage would be above 60%, and therefore still forming the preponderant part of the obligations.
Yeah, so thank you. I was wondering about the preamble of the contract, which refers to the protected production process. So does this bear any relevance to your argumentation, for example, in this situation that the tribunal were to find that the core of the contract actually relates to kind of like the transfer or acquirement of the production process and not so much about any parts or goods themselves?
Mr. Arbitrator, it would not change the analysis because this production process is embedded in the electrolyzers, which is a good, and where the technology in question is materialized in a physical object, tribunals have opined that they relate to goods rather than services, and this finds support in the 2005 Austrian Supreme Court of Software case number 3, and therefore, even if the tribunal focused on the patented production process, it would not change the analysis. Thank you.
I would like to ask Claimant, counsel for the Claimant, 2 questions. One of them is when considering, here the possible or the potential application of the law of Equatoriana, considering that the law of Equatoriana is based upon the UNIDROIT principles, and the UNIDROIT principles seems to be more clear fit probably to this kind of contract because they apply more general to any commercial contract as well. And they've been also, as you know, in the 2016 edition, especially revised for long-term contracts, as this one in this case, whether that is something that these arbitral tribunals should consider in the analysis in order to reach to the applicable law. That would be one question. My second question has to do with the economic sense for you. I mean, you defend that the CISG is the applicable law here, and therefore, why is that your client decided to accept a 5% price reduction when the CISG, does not provide for the termination for convenience? Thank you.
Madam Arbitrator, to answer your first question of whether the UNIDROIT principles would be more applicable here, Claimant submits that it would not, because when the CISG's applicability regime, Article 1, Paragraph 1A is fulfilled, then the tribunal should determine that the CISG applies.
Sorry if maybe I was not clear. I was referring to the fact that the law of Ecuatoriana is based upon the unidroit principle. So that, therefore, between the two, applicable laws here, we have one that is based upon that, and that was my question.
Apologies, Madam Arbitrator. Even if the tribunal finds that these two laws coexist, Claimant submits that the CISG should apply because it is the lex specialis law when referring to international sale of goods as compared to the unidroit principles which has been adopted in Equatorian laws as their domestic sales law. Now, on the second question of why Claimant offered a 5% discount for the waiver of a right under the Civil Code of Equatoriana, Claimant submits that it was done in commercial prudence. Claimant is uncertain as to whether this right to terminate for convenience is a mandatory provision, and therefore, to cover all our bases and to ensure that the contract is upheld and performed, Claimant offered a 5% waiver of this mandatory provision under the law of Equatoriana, and the tribunal should not infer that Claimant wanted to exclude the application of the CISG. If there are no further questions, then this concludes my submissions. Thank you.
Madam Presiding Arbitrator, members of the Tribunal, and distinguished colleagues, a very good morning. My name is Nishtha Barua, counsel on behalf of the Respondent, Equatoriana Ren Power Limited. Members of the Tribunal, a contract relies on certainty and adherence to the agreed upon terms. The claimant, having breached the contract by failing to fulfill the very first milestone laid down in the PSA, now seeks to shift the goalpost by advocating for its own preferred choice of law. In this regard, over the course of the next 14 minutes, while addressing the submissions of the claimant, I shall be addressing the tribunal on two substantive issues. Firstly, the purchase and service agreement is not governed by the CISG, and secondly, the parties have validly excluded the application of the convention. Beginning with the first issue, it is the respondent's submission that the purchase and service agreement is governed by the laws of Equatoriana and not the CISG, because firstly, it is not an international contract under Article 1, Clause 1 of the CISG. Secondly, according to Article 3, Clause 2, the preponderant part of the claimant's obligations were that of services and not of sales. Beginning with my first submission, Article 1, Clause 1 of the CISG states that the parties to an agreement are to be from different contracting states. The mere fact that the claimant is registered in Mediterranean does not automatically establish internationality under Article 1, Clause 1, as artists to determine the relevant place of business. To be called a place of business, the place must have a certain degree of permanence and stability. The claimant and the Volta transformer in the present case did share a stable relationship. Volta transformer was claimant's long-term business partner and was producing nearly exclusively for the claimant at the time of the conclusion of the contract, as provided on page number 28 of the record, 7th line from the top. Furthermore, the claimant heavily relied on the transformer as the most important element of the plant, which was also being delivered by Volta transformer. Furthermore, Volta transformer was also delivering 40% of the electrolyzer stacks. Volta electrolyzer, a 100% subsidiary of Volta transformer, was performing the non-transformer related tasks. Therefore, when we look at Article 10, Clause A, and look at the closest place to the performance of the contract, it is Volta transformer which was performing most of the obligations of the purchase and service agreement in Equatoriana. making the purchase and service agreement domestic in nature. Furthermore, moving to my second submission, Article 3, Clause 2, as stated by my opposing counsel, excludes...
Sorry, before you go into Article 3, Councillor, I was wondering whether actually we have a contract, whether it's clearly stated that one party is from Mediterranean, the other one from Equatoriana. We also have a termination notice clearly addressed to the party in Mediterranean. So therefore, is not that the end of the story here in order to apply the convention? Is not, going through that exercise of the internationality of the contract, as you were explaining, is not going too far from what Article 1A requires? Thank you.
Madam Arbitrator, when we look at Article 1, Clause 1, and we look at Article 10, Clause A, we take a broader look at the Convention. We find that a place of business does not need to have a legal tie between the relevant place of business. In the case of Target Corporations versus JJS, the Canadian address of the seller was provided. The Canadian office was responsible for the conclusion of the purchase and service agreement. However, the court held that the U.S. place of business was considered the relevant place of business as it was performing most of the contract, which is very similar to the current factual matrix. In the present factual matrix, while the Mediterranean office of the claimant was responsible for concluding the PSA, the main obligations and the performance of the contract was being done in Equatoriana, therefore making it a domestic contract.
I was wondering whether actually the internationality of the contract that you were commenting here is of importance in the application of the Convention if you read Article 1.3 of the CISG that disregard precisely both the nationality of the parties and the commercial nature of the contract. So therefore, either by a direct application or by analogy of Article 1.3, we might disregard this internationality criteria. What do you think on that?
Madam Arbitrator, in the present case, the contract is not international in nature, as parties performing the contract are both based in Equatoriana. The plant was also being built in Equatoriana. Therefore, there is no internationality aspect in the present case. Furthermore, I proceed to my submissions on Article 3, Clause 2. As stated by my opposing counsel, Article 3, Clause 2 excludes contracts in which the preponderant part of the party which furnishes the goods also consists in the supply of labor or other services. Before I begin with my submissions on the preponderance of the agreement, if I may direct the tribunal to page number 2 of the record, which contains the request for arbitration. And if I may, for the tribunal's convenience, read paragraph 1. Claimant, Green Hydro PLC, is a medium-sized engineering company specialized in the planning, construction, and sale of plants for the production of green hydrogen and connected services. Members of the tribunal, the claimant themselves refer to themselves as a company, as an engineering company, which specializes in construction and planning as well as the sale of plants. Now, with this as the background, the CISG Advisory Council Opinion Number 4 lays down 2 tests that the tribunal can consider while looking at the preponderance of the agreement: the economic value test and the essential criteria test. We look at the essential criteria test when the economic value test is inappropriate or inapplicable to be applied. In the present case, it is the respondent's submission that the economic value test is inappropriate to be applied. The claimant referred to page number 17 of the record, to the table provided therein. However, members of the tribunal, this table is not a reliable source for data interpretation. as it does not contain, firstly, the 5% price reduction from 300 million euros to 285 million euros, and secondly, it also does not contain the values for options. My opposing counsel stated that options were contingent and might or might not have been exercised. However, members of the tribunal, the options were to be exercised by the claimant, and the claimant was aware of it. The parties had decided that the options were to be exercised in due consideration, and no further contract was required. Therefore, without the values for the options and which options were to be exercised and the 5% price reduction, there are no values in the case record that the tribunal can look at while looking at the economic value test, and therefore has to refer to the essential criteria test and look at the objective of the PSA and the intention of the parties. From the components of the contract and the intention of the parties, it is clear that the parties, since the very beginning, intended to enter into a turnkey or a construction contract, but not a sales contract. The contract between the parties has been named a purchase and service agreement. Furthermore, the claimant has been called a contractor and not a seller, and the respondent has been referred to as a customer, not a buyer. The wording of the PSA clearly indicates that the parties wanted to conclude something more than a mere sales agreement. Furthermore, the main obligations of the claimant in the present case was the construction of the plant. The claimant heavily relied on the delivery of transformers and electrolyzer stacks. But members of the tribunal, the PSA in the present case was not for the delivery of these electrolyzer stacks or transformer. It was for the construction of a whole unit, of a plant, and not for the delivery of the goods that my opposing counsel stated. And if I may further direct the tribunal to page number 8 of the record, which contains the request for quotation. And if the tribunal may look at objective of the request for quotation. And if I may read it with the tribunal, the request is for a quotation for the engineering, planning, construction, and delivery of a plant turnkey for the production of green hydrogen. Looking towards the last point, training and maintenance services for the first year of operation. Members of the tribunal, the word sale, goods, or purchase are hardly ever mentioned in the PSA or the request for quotation, which clearly indicates that the main obligations of the claimant in the present case was the construction of the plant and the services that came along with it. This concludes my submissions on the third issue. Moving forward to the final issue, the respondent submits that the parties in the present case have validly excluded.
Sorry, let me go back then to Article 3. So to be clear, so you're saying that claimant's obligation related to the engineering, the planning, construction, those are services obligation. Is that what you're considering under Article 3.2?
Yes, Madam Arbitrator. In any case, these obligations cannot be considered sale of goods obligation. Therefore, the preponderant part is that of services or construction.
But I think you were relying on opinion number 4, right? Of the advisory council. Doesn't that opinion say that actually the services in relation with the manufacture or production of the goods, meaning here engineering, planning, and construction, are part of 3.1 and therefore is a CISG contract?
Madam Arbitrator, in the present case, the delivery of goods obligation of the claimant were merely of electrolyzer stacks and transformers, beyond which the obligations entail the building of the plant, the construction of the plant from the ground up. This showcases that the main obligation of the claimant in the present case was of services or was of building the contract. Moving forward to the final issue, Seeing that I've nearly elapsed my time, could I get an extension of 40 seconds to conclude my submissions? The parties in the present case have validly excluded the application by way of Article 6 and Article 8 of the CISG. Article 6 of the CISG states that the convention is not a mandatory law of a contracting party, and it can be impliedly or explicitly excluded by the parties. In the present case, the respondent submits that the parties impliedly excluded the application of the convention. When we look at the choice of law clause, which is at dispute, we can also look at Article 8 of the CISG to construct intention of the parties. And in the present case, the parties did intend to exclude the CISG. And furthermore, according to Article 8, Clause 2, the claimant was reasonably aware of this exclusion. The two facts that are important for the tribunal's notice today are firstly that the choice of law clause in the earlier model contract, which had the explicit reference to the CISG, was changed. And furthermore, Ms. Heidi Smith, the head of the legal department of the claimant, was aware that the choice of law clause in the present case leads to the application of the non-uniform domestic law of Equatoriana and not the CISG. The parties in the present case were reasonably aware that the CISG will apply. Furthermore, the termination for contract clause in the purchase and service agreement was negotiated by the parties. This clearly showcases that the claimant was unaware or was unsure of the CISG's application. And therefore, in the present case, the parties have excluded the CISG and the claimant was reasonably aware of it. If there are no further questions, this marks the conclusion of my submissions.
Yeah, well, about this exclusion of the convention here, when the party chose, I mean, as far as I understand, the majority of case law and scholars says that when you consider the law of a country, then that includes the CISG. So I don't. So my question is, in that regard, would it be necessary almost to have an express exclusion of the convention instead of relying on an implied exclusion of it?
Madam Arbitrator, in the previous model law clause, we had the explicit reference to the CISG. However, the respondent excluded or removed this explicit reference to the CISG. Therefore, it showcases the clear intent of the respondent that it wanted to exclude the application of the CISG and merely wanted the law of Equatoriana and only the law of Equatoriana to apply to the agreement. And the claimant, having previously used the model contract, was aware of this change.
But this exclusion is just done by the respondent. Is there any evidence in the record that the claimant was well aware of that prior to the entering into of the contract?
Madam Arbitrator, as stated before, Ms. Heidi Smith, the head of the legal department of the claimant, was aware that the choice of law clause in the PSA refers to the law of Equatoriana. And this is provided on page number 53 of the record, clarification number 11.
Yes, the in-house did consider CISG, but they also referred to all applicable rules. So it seems as a matter of caution, she has exhausted different types of possible applicable rules or possible arguments from the other side. Other than that, is there any other thing that can point to knowledge on the claimant's part about the application of CISG or the exclusion of the CISG?
Madam Arbitrator, Ms. Heidi Smith was reasonably aware, and while she did check under other jurisdictions, she clearly understood that in the present case, the choice of law clause would mean the law of Equatoriana. Furthermore, having previously used the model contract, the party was aware that this change, where the explicit reference to the CISG was given, has been removed, which showcases that the party was aware that the CISG does not apply in the present case.
Just another question for you, counsel. If your client was thinking of the application of the law of Equatoriana, what was then, why is that an entity, a state entity, actually decide to agree of the exclusion of the convenience right of termination, considering that it was, or it's considered to be mandatory under the law of Equatoriana?
Madam Arbitrator, while the termination for convenience is only provided in Equatorian law and not the CISG, it further showcases that the claimant was aware that the CISG does not apply. Furthermore, we negotiated on termination for convenience for a further 5% price reduction, therefore deviating from Equatorian law.
Any further submissions?
No, Madam Arbitrator.
Thank you. Claimant.
Madam President, members of the tribunal, one point in rebuttal on the exclusion of the convention. Earlier, Madam Arbitrator opined correctly that indeed, if parties adopt the law of a contracting state, the CISG would apply. And Madam Arbitrator asked why counsel for the respondent was relying on an implied exclusion. Now, even if we take respondent's case to the highest and rely on implied exclusion, the tribunal will not be able to find implied exclusion because implied exclusion is normally found when parties refer to the specific domestic sales law in question, and this refers to the Civil Code of Equatoriana. And this finds support in the 2023 Interal against Select case in the Santiago Arbitration and Mediation Center, as well as the 2023 Sotafin against Park Plus Inc. case in the Swiss Arbitration Center. And because respondent has never referred to the Civil Code of Equatoriana in negotiations or in the contract itself, claimant submits that parties have not excluded the application of this convention. Thank you.
Madam Presiding Arbitrator, members of the tribunal. Before I address the rebuttal raised by my opposing counsel, I would like to respectfully emphasize that the acceptance of any single of the respondent's submissions is sufficient to establish the respondent's claim. Furthermore, addressing the point raised by my opposing counsel, in the Golden Valley grape juice case, the Golden Valley Court clearly held that any national law or a reference to the national law of a state is an implied exclusion of the convention. Therefore, the parties in the present case were not to refer to a specific code of the law of Equatoriana, and the broad reference to the law of Equatoriana and the further exclusion of its conflict of laws principles is enough for the exclusion of the CISG.
Anything else from the parties that we need to deal with?
No.
And thank you. Sorry. Thank you, counsel, for the submissions. We will, of course, we will deliberate and we will have our decision in a few weeks' time. Thank you for your time.
Sorry. Hello. Well, I was going to say let's give a big round of applause for everyone, but thank you very much for that. Thank you, tribunal members. Thank you to both sides. Could I ask you to do a quick smile to wonderful Jerry down here to take a picture before I let you go? That's asking a lot of them. And now Jerry's going to turn around and take a picture of everybody in the room. So look for him and smile as if you're so happy to be here at 10 a.m. in the morning. shoot somebody. So my tribunal members, please go ahead and proceed to the VIP room to deliberate. Teams, stay here to stay neutral. Everybody out there, stay there as well for the time being. Louise will, well, actually, you guys know where to go. We'll come get you before you. Louise will take you to the VIP room. So, now, everybody here, I sent a push and a email this morning. As you know, 12 p.m. is our group photo. We will need everyone to vacate this room irrespective because they need to re-prepare, re-clean up, and set you up for the gala. So please make your way to the 19th floor, the Hopewell Park, which is right outside, and congregate there. Our wonderful team in the back will help lead you there, and we will take our group photo right at 12 p.m. Teams, you can also obviously go back to your coaches and then go together. Please do remember to come back to this room around 12:45. There is a seating chart outside with your team names, and for individuals who bought their tickets individually, your team name, or sorry, your seat number is also outside. Take a look there, and then you will come back to your assigned seating. Lunch will start promptly at 1 p.m., but for now, everyone get up, exercise your legs, and please go to the 19th floor.